When we start talking about opening statements, I want to talk about what I do to prepare for it in the first place. So welcome to another video on our jury trial series. This week we are going to be discussing opening statements, which are my favorite part of the trial. My process is I typically outline what I want to say, and then after I've outlined what I want to say, I actually write out word for word what I would like to say in front of that jury. After I've written that out and kind of went over it several times and I've internalized it, then I develop what I call tripwires. And what tripwires are simply one word on a sheet of paper that triggers my mind, that when I see that word, I know to immediately start talking about that particular topic. If I lose my train of thought, I can look down at that word and automatically I know exactly what I need to talk about next. A question I get quite a bit from younger trial lawyers is when I'm up there giving my opening statement, should I just stick to my script, what I have planned, or should I be a bit more flexible? And I always say it just depends on your experience and your comfort level. I feel very comfortable being very flexible up there. If it's something that I feel, if there's a reaction from the jury that I noticed, then I'll go with that. But if you haven't tried a lot of cases and you're nervous and you're concerned that you may lose your train of thought, I would suggest sticking to your tripwire, sticking to your outline until you get a bit more comfortable. So now we're at opening statements. And obviously I'm looking at this from a plaintiff lawyer perspective. The first thing that I'm typically talking about to the jury is I'm laying out the rules. What were the rules that were potentially violated by the defendant's conduct? I then tell the jury the story of what happened to my client. I just lay out the story in an objective manner. I'm not advocating at that particular time because remember, this jury has just met me. I haven't built that rapport with them yet. And essentially, you're proving through that story how the defendant violated the rules that you discussed prior to talking about that story. And next, you'll get into your client's human story. Juries want to know, how was this person before this wreck? Who were they as a person? Who are their friends? Who are their family? What did they love to do? What did they lose? What was taken from them? Explain it to the jury in a way that will make them connect and like your client and want to help them. And then we transition into talking about damages. A question I get a lot is, if I have a case where there's a significant injury like a brain injury, but the medical bills are very small, what should I do in that case? And really it's a case-by-case basis, but a lot of great trial lawyers say you should waive those medical expenses and just try the case on non-economic damages only, and just try the case on that brain injury and the past, present, and future pain and suffering that your client is going to suffer as a result of that brain injury. Next, you talk about the defenses. And the reason why you want to go through and contextualize and discuss their potential defenses is because you don't want the jury hearing for the first time something that could potentially be harmful to your case that you didn't mention and that you didn't bring up, because that detracts from your credibility. So bring it up before the defense does, address it, put it in context, and move on and dismiss it. And to end, in my opening statements nowadays, I will suggest or tell the jury what the case is worth during opening statements. Some trial lawyers don't like to do it. I do, and I would suggest doing that if you have a substantial case. And in addition to discussing damages and the value of the case in opening statement, I always think it's important to incorporate themes into your opening statements as well. Something that the jury can hang on to and remember, and that you can incorporate throughout the trial so that when they're back deliberating, they are repeating your themes to each other when they're talking about the case.